Good morning and welcome to today's webinar. Happy Friday, everybody. What families need to know about planning for a loved one with special needs, presented by Elville and Associates Managing Principal and Lead Attorney Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be moderating today's presentation. So welcome to those that are new to our educational webinar series and also to those that are frequent attendees. We encourage your general questions today, so please note them in the questions panel on your screen and we'll pause periodically to address them. As always, your questions really add value and help the presentation. They help others learn, so don't be shy in posing your questions at any time. You received the presentation slides from me by email yesterday to take notes on them if you wish. The presentation slides are also available in the section marked handouts on your screen to download at this time. To our advisors on today's presentation, welcome as well. You may also receive 1.5 continuing education hours for attending. So if I don't have your ID number yet, please email that to me as soon as possible, as I'll be submitting your CE hours for approval on Monday. I'll also be submitting and sending out these certificates to everybody at that time. Everyone will also receive a post-webinar feedback email right after the presentation, and we ask that you please take just a couple minutes to fill out this very brief survey to offer us your feedback about the presentation. And we read and value every comment that you have to share with us. Here at Elville & Associates, we want to be a resource to you for your families and your planning needs, so consider a consultation or a document review with Steve after today's presentation. Consultations are a great way to get your specific questions answered, have Steve understand your individual situation, and help create solutions and a path forward for you. So I'd like to offer Steve and the firm a brief introduction before we get started again. So for those of you not familiar with us, welcome to Elville & Associates. We were founded in 2010 in Columbia by Managing Principal and Lead Attorney Stephen Elville. We offer many different practice areas here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection. We have 7 attorneys, 12 staff members in 5 locations, and Steve and I are coming to you from the Columbia Gateway Community location today. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. We do focus on education a lot here at Elville & Associates, and we do that in several ways. We do that through our planning processes with our clients. We offer over 100 educational webinars and workshops in the communities we serve each year through all of our attorneys, including Mr. Elville, and also by way of our accredited client care program. We're one of only 2 firms in Maryland to have an accredited client care program, or CCP as we call it here, accredited by the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind with every client every day here at Elville & Associates. A little bit about Steve. His work as an attorney for the past 20 plus years, 23 to be exact, I believe, has been centered in elder law, special needs planning, and estate planning with an emphasis in areas of tax planning and asset protection. A member of many different national membership organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. A very seasoned speaker, if you haven't heard Steve present before, presenting at many webinars, workshops for businesses and their employees, conferences, and continuing education events each year. Steve was also named to the Maryland Super Lawyers list for an 8th time in 2023 and a 7th consecutive year, so congratulations to Steve. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization that he founded in 2014, and I'm very privileged to be the executive director of. So if you'd like to learn how we work to make a musical difference in the lives of children each day, I would love to speak with you, and please feel free to reach out to me at a later time. But for now, we're going to talk about special needs planning. I'm going to see if Steve is on yet. He was having some trouble connecting in the conference room earlier. So I do see Steve is just logging in, so that's a good thing. 1 second here. Yep, he should be with us in just a minute or two here. We do have a brief poll that we'd like to get started with. To get to know our attendees. 1 second, everybody. Hi, everybody. Steve is having some connectivity issues here, so we are going to try to get started here just as soon as possible. So thanks for your patience. Just hang in there with us. I appreciate it.
Oh.
Hello, everybody. Thanks for your patience. We are here. Steve, are you there?
Okay, Jeff, I think we've
There we
resolved
go. Okay.
our technical issues.
So, all right.
Thank you so much, Jeff.
Sometimes good things take time. I appreciate everybody's patience. And so we've gone through our introduction. We're going to bypass the poll today. All that needs to be known is that you're here to learn about special needs planning today. And so I'm going to turn it over to Steve. And thanks for being here, everybody.
Good morning, everyone, and thank you, Jeff, for that introduction. And thank you, everyone, for sitting through our technical difficulties this morning. And we are going to do our best to move along with the presentation. In the interest of time, we know your time is valuable. Thank you for spending time with us on this Friday morning. It's almost springtime. Happy Friday to everyone. I am privileged to present to you today and to continue our series of educational presentations here at Elville and Associates with the assistance of my longtime colleague and friend, Jeff Stauffer, who is our Community Relations Director, and all the attorneys and staff here at Elville and Associates. We appreciate you and your time. So with that said, let's get into our special needs planning presentation. And for those of you who have seen this presentation before, I want you to just understand that it's okay to look at this more than once. It's a lot of information to absorb. For those of you who have never seen this presentation, please allow me to just preface this by saying I want you to walk away with something substantive, including the presentation itself, that you can use as a resource. And it's been my privilege to be involved with the special needs planning community for many years and to be a resource. And we want to be a resource to you. We're going to teach you today, give you the benefit of my knowledge, and I would look at this maybe as a mini masterclass, something that represents maybe the culmination of my experience in over many years in special needs planning. But that's good and well, but I want you to walk away with something that you can grab onto and use substantively in your own life and for your own loved one with special needs and disabilities. All right, Jeff, so I'm going to move the slides forward. Of course, everything we discussed today is not meant as legal advice because it really can't be. We're not meeting face-to-face and we're not in an attorney-client relationship, but we are going to do our very best to provide you an overall educational scope of this subject matter. So there's lots of reasons for planning for a loved one with disabilities. You're going to have reasons that are very personal to you. And no one can be you. No one can know your personal experience and the situation that your loved one with disabilities has, whatever that situation may be. What we want to do ideally is build a world of support for that person and also not restrict their potential, of course. Everybody's situation is different. Every person with disabilities has a certain a set of circumstances, and you know yours, and we are going to work towards a situation where even if you don't know the why 100%, that you'll be able to have a series of epiphanies through counseling and advice and time to think, and we're going to talk about that. Providing financial security, understanding means-tested benefits, selecting a proper team, dealing with housing issues, which I know for many of you is near and dear to your hearts, providing for advocacy, caregiving, coordinating whatever the makeup of your family is, coordinating that entire thing, making sure the beneficiary or the loved one is protected from creditors and predators and all of the things that are happening in the world that are not necessarily positive. And for some of you, preserving assets for other heirs after the death of our loved one with disabilities is important. These are just some of the benefits of planning. You're going to decide what is important to you and what isn't. Jeff and I have a fond saying in our presentations that we're going to be intentionally redundant. We're going to say things more than once. We want to say things more than once, not just because we forget ourselves, but because we're really trying to drill down into some subject matter that we want you to remember. So here we go. Having the team of advisors we think is important. Not all of you will always have a team of advisors, but a financial advisor, a CPA can be very beneficial. Having those people, those professionals interact with your estate planning or special needs attorney. Having advocates, having an insurance professional sometimes is very important. Trust protectors, having that person on the team. What is a trust protector? Well, I promise we're going to get more into that. But the thing I want you to take away from this slide is the idea of building flexibility. We're living in a fast-changing world. All it takes is one day of looking at the news, and we know just what's going on all around us. We want to build flexibility into our planning as much as is practical for you. So let's talk about creating this effective plan. And I'm here to show you now another set of bullet points. We want that time to think. I mentioned that just a few minutes ago. I know just from personal experience in dealing with hundreds or even thousands of special needs families, families with a loved one with disabilities, you probably don't have a lot of time to think. In a planning process of counseling and partnership, this is what we want to have, is the time to actually think about these issues. Where will your loved one live and who will they live with? What type of care will be required? We just talked about that a few minutes ago. Will a guardian or conservator be necessary? Or can we avoid guardianship? And there are new options in the law. Who else will need to be involved? Possibly this team of advisors. What are the future challenges? What kind of economic lifestyle do we want to provide? What kind of layers can we build into the planning so that there are safety nets? And then again, we talked about understanding our purpose. Whether it's special needs planning, whether it's tax planning, whether it's charitable planning, whatever it may be, if we know what our purpose is, we can get from point A to point B. And understanding that a process is something that should be followed, not just to talk about these concepts, but to actually engage in a process where you actually can consider all of these things. This is very difficult to do on your own, which is why we are here to be a resource to you. Now, along the lines of really thinking through things and taking all of these things into consideration, and I'll just say at the outset, this is a lot that I'm throwing at you here this morning. So remember, you are not expected to walk away from this and understand everything. But let's take it one step at a time as we continue on. A memorandum of intent. How many trusts do you think that are out there? Out there in Maryland, out there in the Mid-Atlantic, out there in the United States? Well, thousands and hundreds of thousands at least, maybe millions, I don't know. How many of those trusts actually have a letter of wishes or a memorandum of intent, whatever we want to call it? How many of those trusts actually have this extra memorandum attached to the trust expressing these things? What are your goals and values? What are your preferences for your loved one's care? What about your loved one? What are they like? What are their needs? What are their medical needs? Who are their family members? Who are their trustees? And so forth. This is arguably one of the most important things in special needs planning. And as you can see, it has nothing to do with legal technical things. It has nothing to do with trusts. It's a memorandum. And you can create your own memorandum, or we can give you a template. And I want to just really spark your imagination here about how you can customize your special needs planning for your loved one by using something like a memorandum of intent. Now, estimating income and expenses, getting to the financial side. These are some elementary things here that I'm going to encourage you to think through, not only with your family and your family members or your spouse, but I want you to think through these things with your financial advisor. So if you don't have a financial advisor, we want to help connect you with one. Um, there are all kinds of advisors out there. They come in different forms and varieties. We want to help you form and use the resources of a financial advisor. You may not know this, but financial advisory firms today have a great set of tools. They have lots of deep tools that you can use. And I strongly recommend that you take advantage of those tools for forecasting into the future, for estimating how much will be needed, whether or not you should use life insurance, which is a big driver. I want you to just know that these resources exist, and we want to help you take advantage of them. Here are some very old school style spreadsheet illustrations of just what I want you to be thinking about. How much do we need today? How much will we need tomorrow? What is our goal? See, everything is driven by goals. And again, I want you to be encouraged to use advisor resources, CPA resources, financial advisor resources, insurance company resources, all for your benefit. Don't forget that this exists. Now, one of the things that we're going to do is we're going to stop occasionally during the presentation to take questions. I'm not just going to ramble on for all these 90 minutes, or at least the time that we have remaining. But at this point, I'm just going to assume there are no questions yet. Jeff will interrupt me if there are. And we're going to go right now into a different subject. So we've talked about purpose in planning, understanding a little bit about the scope of the people who should be involved. We've talked about the considerations that at the outset you should just let sink in and start to consider. And now we've talked about the financial side and using the resources that are available. I promise we're going to get to the special needs trust portion of the presentation, but let's not forget some of these fundamental elements, like planning for the incapacity of our loved one with disabilities. So this person in your life could be a person that has cognitive abilities. They have high functioning cognitive abilities. They have what we would call, in the legal side, they have legal capacity. Now, if they have legal mental capacity, they can execute powers of attorney and advance directives. Why would they do that? Well, if they're higher functioning, they can appoint an agent. They can appoint their agent to help make those decisions if they are not able to do so themselves. Okay, so in the highest and best way of thinking, in special needs planning, our loved one would sign powers of attorney and advance directives if they have the mental capacity, and by doing so, they avoid a guardianship. Okay, now on the other end of the spectrum, we have a person, and maybe your loved one is already under a guardianship. They are the ward of a guardianship, or they need protection of a guardian. So on this side of the spectrum, we have the person who can sign powers of attorney and advance directives, and they can exercise legal capacity, and they can make their own decisions and know that there's a backup if they can't make their own decisions. On this side of the coin, on this end of the spectrum, we have the person who does not have this capacity, or is very borderline and needs the protection of a guardian. Okay, so we have these two extremes, and we have to determine on this continuum where your loved one is. Now, if there is mental capacity, your loved one can also have a supporting decision maker, and that's the last bullet point here. And that's a different subject for a different day. Jeff is happy to send you a link about our supported decision-making workshop, or for our supported decision-making workshop. And also, I wrote an article in our, not the current newsletter, but the one before this one, where I expounded into great depth, including the statute about supported decision making. So let me go back to using my hands again. Here we have a person who can exercise capacity, sign powers of attorney, advance directives. On this end of the spectrum, we have a person who cannot do that and needs the protection of a guardian. And in the middle now, we have supported decision making. And although this webinar is not about supported decision making, I'm about to give you the definition of it in my view. Supported decision making is about the person with disability saying to the world, and also the law says to the world, this person can make their own decisions to whatever extent possible, provided that they have the support to do so. So I'll say that again. This is a person who can make their own decisions, and this is a very broad scope of persons. This is no longer pigeonholing someone as either someone with capacity or someone with no capacity. This is a true middle ground that a person, no matter what their capacity is, in a broad sense, can make their own decisions, providing that they have the support to do so. So that's what I want you to think about as far as this continuum of incapacity planning or planning for capacity, let's say, depending on how you're looking at it. The last thing I will say, that if a person needs a guardianship, the Maryland law is so broad, it has gone from 0 to being extremely broad. It provides, like some states do, that if a person needs the protection of a guardianship, they can still have a supported decision maker. So that is really, in a nutshell, what is happening here on this slide as we think about how to handle the capacity or incapacity of our loved one with disabilities. All right, let's talk about public benefits, but before that, Jeff, do we have any questions? I'm moving a little more quickly than we normally do.
Thanks, Steve. We've got a really good question here, and the question is, what qualifications do I want to look for in a financial advisor?
Thank you for that question. So that's a really great question that would take a little bit of time to answer, but I think that it's going to be based on your goals. Most people today would say, I want to deal with a financial advisor who is a fiduciary. That means that they are not selling products, and that's a very crude way of trying to save some time here in the explanation. This is a person who has to invest based on my best interests and what's best for me and my family. And obviously, financial advisors come in different sizes and shapes. Some of them are certified financial planners, which is a very high level of testing and certification. Some of them aren't. Some of them specialize in different types of approaches. So I think it's a question of, what is the best fit? How does that financial advisor work with the team that you might want to build? And I would strongly recommend that if you need, let's say, recommendations, that you interview certain financial advisors and get a feel for this, and really understand that this is a person that you also need to have a partnership with. And not all financial advisors have to have a special needs child to understand your situation. I know some people with loved ones with disabilities, they very rightfully so may say, no one really understands what I'm going through. And it is true that many financial advisors, of course, do not have a loved one with disabilities per se, but there are some that are very familiar with dealing with special needs planning. And those people, of course, are great because they have that inside knowledge. But that a financial advisor does not necessarily have to have the inside knowledge of special needs planning to understand how to be a great financial advisor, of course. But what we want, in my opinion, is someone who's well-rounded. They're a fiduciary. They understand the need for insurance if there's a potential need for insurance, but they also understand you, at least to a reasonable degree, and what you're dealing with as a parent, loved one with of a loved one with disability. So sorry for that not so short answer, but it's a broad topic and we could talk about that offline. So let's
Okay.
talk about public benefits. Jeff, any other questions?
No, I said that that's very good. That's all the questions. Let's go ahead.
Thank you. Thank you.
Yeah.
So understanding public benefits, we're going to try to do this in a nutshell this morning. This is critical for trustees. So what do we need to know about trustees? Well, we'll talk about that in a nutshell, although we do have an entire webinar on how to understand trustee selection and how to think about it. Trustees need to first understand public benefits to be a good trustee. Second of all, they need to read the trust and they need to understand the terms of the trust. So with that said, let's look at the following slide. One of the most important things I can describe today for you is this public benefits at a glance. I want you to work from left to right. So many of you have loved ones that are either on supplemental security income, SSI, or they will someday qualify for SSI. And so let's start there. So the person who receives SSI, which is means tested, we all know that at the current time, that loved one with disabilities cannot have more than $2,000 of resources, of assets in their name. And as a result of that, they qualify for SSI. They also get Medicaid, or in Maryland, we call that medical assistance automatically. So the person who receives SSI on this left side, by definition, receives medical assistance in addition. Now, at some point, if that person was disabled prior to 22, and if you're writing this down or you're marking up your copy of the presentation, I want you to go to this middle column now. We're not going to have much to say about the right-hand column. We're going to focus on this middle column. This person is transitioning from an SSI recipient into the status of a disabled adult child. This is one of the things that I find that our attendees at workshops do not understand. So if you do not understand this, just know that if your child or loved one does not have their own work record, they did not go out into the workplace enough, they either did not do any work or they didn't go out and establish their own work record to a certain extent, they can qualify and will qualify based on your work record as a disabled child who was disabled prior to the age of 22. That person will now receive SSDI, Social Security Disability, and you'll notice that they receive Medicare. That person now receives Medicare after a certain period of months, but many people in this middle category, they also receive Medicaid. And many of you on this webinar this morning understand this. So just understand that if they do qualify as a disabled adult child, as we will see in a future slide here, they will receive an amount equal to 50% of their parents' retirement amount in Social Security. And at your death, at your passing, they will receive 75%. Now, the far right column has to do with Section 8 housing. We will maybe just call this HUD housing. And the biggest thing to take away from this slide, this column, I should say, is that HUD presents a unique challenge. I am dealing with a beneficiary right now who lives in HUD housing. Every distribution that we make from his or her special needs trust, that trust is going to possibly hurt that person in the sense that it's going to increase the rent. So there are ways of dealing with this, and we want to understand this. That HUD is a bit of a challenge, and the HUD rules are changing. And there is a webinar on my own scheduled for me to review the new HUD rules. So if your loved one lives in HUD housing, we have to talk about how to deal with that. But back to the middle column, this is where I want you to understand that if you have a disabled adult child, that disabled adult child many times still has means tested benefits. The SSI was means tested. The SSDI is not necessarily means tested because your child could have or loved one could have $1 million in the bank and still receive SSDI. But the underlying benefits like waiver benefits, the DDA benefit, many other means tested benefits, those still require means testing, and therefore the special needs trust is not only important for the person in the SSI column, so to speak, but also the person in the SSDI column if they are receiving means tested benefits. Now, not all special needs loved ones, disabled loved ones, receive means tested benefits. So this is something that's important to know, but this is public benefits at a glance. Now, we're not going to talk, just because of the interest of time, we're not going to talk about the SSI testing and how a person qualifies for that. That's a different subject. The definitions of disability, I'm going to leave this here for your review and reading. Here are the resource tests for single or married individuals. Yes, a person can be married and still receive SSI. Note that even under the strict SSI rules, a person could own a home and a vehicle, but this does not necessarily mean that it's a good idea for them to own those resources in their own name. Most of the time, that's going to be owned by a special needs trust. Now, here are the current SSI rates. We're not going to spend a lot of time there, but this is important. This particular slide, if you're dealing with a loved one on SSI, just know we are very keenly interested in these concepts: unearned income and earned income. We know, and if you don't know already, you should know, that your loved one could actually lose their SSI if they earn too much money. And we just want to make sure that we don't reduce SSI to zero because your loved one would lose their medical assistance. Now, many of you are familiar with the 1/3 reduction for in-kind maintenance and support and so forth, or the presumed maximum value rule. Here is this slide in a nutshell. SSI is for food and shelter. So we all know that food and shelter is very expensive. If you are providing food and shelter for your loved one, meaning they are living with you, then their SSI will be reduced by 1/3. So that's the 1/3 reduction. Don't worry about it. It cannot be reduced, as far as this is concerned, any more than 1/3. So if you are having if your loved one's SSI is subject to a 1/3 reduction, just remember that there are techniques that can be used to avoid that reduction of 1/3, and then you can decide what you do with either rental income that you receive from that person, and there are ways of dealing with what to do with that money. SSDI eligibility, the only thing that I want you to see here is this slide. Here we're talking about the same thing again, intentional redundancy here, talking about the disabled adult child benefit. Now remember, don't get this confused with the age 26 limitation for the ABLE account. This is a different thing. This is the disabled adult child being disabled prior to age 22. Medicaid and Medicare benefits, we're also just going to include this here for your consumption and your education. I'm not going to spend time on these particular slides. Section 8 housing, there actually is such a thing as nice Section 8 housing. We've actually seen some nice HUD housing. It doesn't necessarily mean it's synonymous with poor housing, but it does have ramifications for special needs trusts where, again, as I mentioned a few minutes ago, distributions from a special needs trust can be and will be construed to be income to the beneficiary, which can cause their rent to increase. So we have to be careful with this, and there are some techniques to be able to, hopefully under that person's situation and subject to that person's situation, to be able to use to avoid this. Housing, we know that some of you are planning to leave your house, your residence, into a supplemental needs trust for the benefit of your child or loved one. Some of you will charge your trustee with this idea that you're going to do, trustee, what is best, whether a house needs to be purchased or a living arrangement needs to be made, which many of you are uniquely situated in certain circumstances to know what that should be, or whether it's group housing or housing through an organization in the community. So housing, I know, is near and dear to your hearts, and it is part of planning for special needs. So with that said, we're going to launch now into what is a special needs trust or supplemental needs trust. And I'm just checking my time. And Jeff, I think actually even with our delay, we are still on time. Stop me at any time if there are questions. So
can we go ahead and answer one question, Steve?
Go right ahead, Jeff.
Thank you. So question is, when does the transition from SSI to SSDI happen?
Thank you for that wonderful question. This is going to happen when the adult who has the work record, meaning the parent usually, that parent is going to start their own Social Security. So that's when that's going to happen. And there should be a changeover at that time from SSI to SSDI. And that's what the disabled adult child benefit is.
Okay, thank you.
All right, thank you. The top column here of these three columns as we go from top to bottom, this column is really the most important thing I want to convey today. So as part of your own estate planning, you're going to want to provide, if we have someone with disabilities and that person is going to have means tested benefits in the future, or we anticipate that they will, or in many cases, some cases, we're not 100% sure, but we want to be conservative, this is the trust that's going to be used. It's called the third party supplemental needs trust. Now that's a mouthful. The third party supplemental needs trust. Now let's go left to right. Anyone can fund this trust. So this is a trust that is funded by you or another family member. And this funding could be from your will or trust to the special or the supplemental needs trust. This could be from a life insurance policy or a retirement plan, or it could be a relative of yours who, of the loved one, I should say, that leaves assets to this trust. So this is the third party supplemental needs trust. It is money from a third party, not that the disabled person actually receives themselves, but money from a third party that comes to a trust from point A to point B, not to the disabled person. The disabled person does not actually receive the funds. And this trust can be established by anyone except the beneficiary. And upon the death of the beneficiary, this is a terrible thing to talk about, but upon that person's death, the money in this third party trust goes where you say it goes, the grantor, you. Where does that money go? Well, it goes either back to you, or it goes back, if God forbid, if you were still living and the person passed away, or it's going to go to other siblings or relatives. So this is the bread and butter. This is the fundamental trust for use in special needs planning, the third party supplemental needs trust. Now going down from top to bottom in the middle column, we see the D4A trust. Now some of you may say, what in the world is a D4A trust? I want you to think about the middle column and the bottom column as what we call first party trusts. These are trusts that the money has actually come to the disabled person. Now we can't go from point A to point B. The money has gone to point C, which is the disabled person. And there are several varieties of these first party trusts. One of the primary ones is the D4A trust. And if you say, what is that, Steve? Where did that come from? It really comes from the United States Code 42 USC 1396P D4A. And I won't repeat that, but I just wanted you to know where that is. It's in the United States Code. And this basically says where a person receives money that is not a good idea, that it's going to have disqualified them from benefits. They can't deal with the money. They don't have the ability to manage their own money. The court and the state, and the states, I should say, will allow this trust to be established under a 1993 law establishing this kind of option. So the person for the D4A trust has to implement this and fund it prior to age 65. So 65 is the limit. This trust can be established by a parent, grandparent, guardian, a court, or notice, the last one, it can actually be established by a beneficiary. If that beneficiary is a person with capacity, they can establish their own D4A trust, or they could have signed a power of attorney allowing someone else to establish it for them. Now, notice the far right column. There is a payback. So this is called a payback trust. Any money remaining in that trust will first have to go to the state, whether it's the state of Maryland or whether it's another state. So this is not preferred, but sometimes it's not an option. A good example is this. What if a loved one was injured at birth, or injured in a car accident or a train accident, or they have received an inheritance? Now we've got to get that money out of that person's name. So many of you have actually seen or heard of these trusts before because they are used for these purposes. Let's say you are a military veteran and you have a military pension and you want that pension to go to your disabled child. Well, now you would have to assign that under a new law about 10 years ago. You can assign your military pension to a D4A trust. It's a payback trust, but there is no other choice if we want to do that. So this is how the government looks at it. The third party trust, no payback. The first party trust is a payback. A good example, lastly, before we go to the pooled trust, is an example where someone who is disabled receives an IRA from a very well-meaning loved one who died and left that IRA to them. Well, now that knocks them off of benefits, means-tested benefits. Something has to be done with that IRA. Well, thankfully, the IRS has come down with many rulings that say that IRA can be moved from the disabled person's name into a D4A trust, can actually be retitled in the name of that trust with no tax. And to my knowledge, that is the only situation in the world where the IRA would be, the IRS, I should say, would allow an IRA to go to a trust, be titled in the name of a trust, not beneficiary designated, but titled in the name of a trust, so that the disabled person would not lose their benefits and there would be no tax. The pooled trust is also a payback trust, generally speaking. And this is a trust for someone who either wants to establish a very low cost trust or is over 65. And Maryland First Disability Trust, the ARC of Northern Virginia, and so forth. These are examples of pooled trusts, and these are called D4C trusts under the code. And as I just mentioned, the third party trust is the bread and butter. It is the only and preferred method, really, of dealing with how to preserve assets for our loved one with disabilities. How would I describe this trust? I would say this. Right now, you are providing the world of support for your child, along with public benefits, agencies, programs, and so forth, whatever they may be. At your passing, hopefully those means-tested programs will always be in place. There's no reason to believe they won't be, and that those will always be there to support your loved one. But the third-party trust is a new world of support that you're creating, that as an additional world, I should say, a new and additional world of support for your loved one, in addition to the world of means-tested benefits, if your loved one is going to be on means-tested benefits. Now, there are times when we still run into clients who are using these other self-help methods, and we want to be very careful here that we're not falling into these traps. I know you probably won't, but this is for your benefit and for your other loved ones to know these are not good techniques to plan for special needs. So leaving an outright inheritance to your loved one. I just gave you a prime example of that, where a well-meaning loved one left an IRA to a person who is on means-tested benefits. Not a good idea, even though the first party trust is there to help deal with that situation. What if we are, through no fault of our own, leaving an asset to a trust that is not a special needs trust? We thought it was, or we thought we did our due diligence, or we were advised that this is a discretionary special needs or supplemental needs trust, but it's not. It's a general needs trust, or it's a trust that is not going to shelter the assets from the world of public benefits. Now there's a loss of benefits. Disinheritance. I actually met a client the other day who said, right now my plan is to disinherit my loved one with disabilities or special needs, and I'm leaving the money to another sibling. So let's talk about why that's not always and never probably is a good idea. Let's look at these bottom bullet points. So let's say we left something to a brother or sister for the benefit of our loved one with disabilities. Well, that sibling could have creditors. So that's the first thing we have to be aware of. They could be lost to a creditor, because anytime we have assets in our own name, that could be lost to a creditor, to someone else actually. What if that person then dies, but they have no will, or they do have a will and it goes to their spouse, and your loved one with disabilities is now without any money? What if the sibling, and many of you struggle with this, many of you have wonderful family situations where siblings are stepping up to the plate to take care of of your loved one with disabilities. Others of you have siblings that are other children in the family that are not going to do this for various reasons. What if that sibling decides, I just can't do this anymore. I cannot take care of my sibling. So there's the money in the name of the non-disabled child, and they've decided they're not going to do this anymore. Or what if they got divorced and the money was lost in a separation and a divorce? Or one of the bullet points I don't have on here, but I've actually seen happen, what if the money was lost to the IRS or the Comptroller of Maryland due to a tax lien? So we have to be careful with these self-help methods, and I strongly recommend that you don't fall back into any of these patterns. So to repeat myself intentionally, the third-party trust is our primary tool. The beneficiary does not create the trust. It does not hold the assets of the beneficiary. The money went from a third party to the trust, not to the beneficiary. And the beneficiary is not the trustee of the trust. It has no payback requirements, and you can design this trust any way you want. It can be revocable during your life. Not always does it have to be irrevocable, and it can be a very flexible document based on modern techniques. Trustee selection is something I mentioned early on. We do have a link that Jeff can provide you on trustee selection. It's one of the biggest issues in estate planning and elder law and special needs today. This could be a family member or a professional, like an attorney or CPA, or it could be a professional trustee. I went to the Heckerling Conference, which is the National Estate Planning Conference that many of us go to every year in Florida. I went there in January. I listened to a panel of certified elder law attorneys, one of whom had a special needs child, and she was a very experienced person talking about her beliefs. And one of the interesting things I took away from that, which may be helpful to you, is maybe the family member is not the best person to be the trustee. Perhaps the family member should be the person who has oversight in a advocate role. Maybe this person is the best advocate, an advisor to the trust, but not necessarily the person who is managing the financial side. So a trustee, if they are a family member, they still should have knowledge of the SSI rules, the public benefit rules. Should there be a family member if there is a large amount in the trust? Should there be a family member if there's a small amount in the trust, being the trustee? What is the relationship? How will they be compensated for their time? One of the arguments from the Heckerling Conference is, how will family members stay interested in the future, as good or bad as that may sound? In the long term, will they be willing to serve for free or for low trustee commissions? What is their knowledge and experience? What is their willingness? So all of this is a very broad topic that we don't have time to entirely drill down into this morning, but just know this is a big counseling issue that we spend a lot of time with clients. Jeff, I'm going to take a drink of water just to see if there's any questions before we forge ahead. It's about 3 minutes to 11.
Thanks, Steve. Let's see here. It doesn't look like we have any additional questions as of yet.
Thank you very much. Okay. Well, thank you for hanging in there with me as we continue to forge ahead to about 11:15. So a trust advisory committee is something that I would strongly recommend you consider as you build flexibility into the planning. So some of you have situations with loved ones that will never need this kind of oversight, or the trustee will never need this kind of help. But remember that trustees can hire professionals, and even though they can hire professionals to get advice and so forth, and they always can do that, the trust advisory committee provision of a supplemental needs trust in today's world provides for more flexibility for the trustee to be able to form a committee of people if he or she needs that kind of input due to whatever circumstance that that trustee is dealing with. The trust protector that I mentioned very early on is a flexibility tool. A trust protector is a special fiduciary, and this takes a little bit of getting used to, so I'm not going to assume that you're going to grasp this right away or that you're even going to buy into this idea right away, but I strongly recommend that you do, especially in special needs planning. The trust protector is a special fiduciary that has limited powers: the power to remove and replace trustees, the power to amend an administratively deficient trust, a trust that needs to be amended because the laws have changed, the tax laws have changed. The Secure Act, which is the most recent tax law that affected retirement plans in a big way, that is a prime example of, let's say, a new special needs trust needing to address the Secure Act issues, because the Secure Act gives our loved ones with disabilities great advantages in continuing to stretch out retirement assets, tax deferred, and in some cases, of course, tax free. The trust protector can make these changes if an old trust needs to be amended. So if we have an issue where there's an accounting that's not being rendered, or trustees need to be removed and replaced, or the trust needs to be modified, the trust protector can be a key tool. Because what I want you to think about is not just today, not just during your lifetime, but let's say many years after your passing, when the world continues to evolve, how will the trust breathe and evolve over time for your loved one? Let's take a look at a contemporary special needs trust, or what we would call, technically speaking, a third-party supplemental needs trust. So here we have trustees, trust protectors, as I just mentioned. The trust probably should have a Maryland ABLE provision if your loved one is eligible for a Maryland ABLE account. And for those of you who are not aware, new legislation has now set in motion a new timetable for 2025, when the age for getting a Maryland ABLE account or qualifying for one is now going to be 46 instead of 26. So this is a big victory for many of you who've been waiting and waiting for this to finally happen. A trust might have an advocate provision. Trustees should know that they can hire an advocate, and they should not forget about it. They should read the terms of the trust and be educated as to what they can do. So the modern supplemental needs trust, in my opinion, educates the trustee, not just sets the legal structure, but educates the trustee about the possibilities and also what they should be thinking about. The memorandum of intent, we want to ideally use that. The Trust Advisory Committee, we just talked about that, and retirement plan considerations, meaning the Secure Act, and how does the trust handle, if you can imagine this IRA or 401k or 403b, whatever it is that's coming into that trust from a retirement plan like an IRA, how does the trust deal with that from the point of view of the Secure Act, which allows your loved one to have the special treatment as an eligible designated beneficiary. This is a new class of beneficiaries. An eligible designated beneficiary, meaning your loved one with disabilities or your loved one with chronic illness, is an eligible designated beneficiary, and therefore they have the advantages under the Secure Act that most people do not have. They have to take retirement plan benefits out if they are not eligible designated beneficiary in only 10 years. Many of you are familiar with this now, but this is something that cannot be overlooked. We need to make sure we recognize your loved one as an eligible designated beneficiary, and their trust is also an eligible designated beneficiary. Jeff found these photos. I don't know where he found them, but he assures me that these are perfect people. These are people who do all of these trustee duties very well. And of course, we're being facetious just a little bit here, but ideally, when we're looking at these concentric circles, we want to make sure that our trustee in special needs planning is capable of and understands all of these things. They advocate for our loved one with disabilities. They understand public benefits. They have their best interests in mind, and they promote independence and quality. They understand accounting, and even if they don't do it themselves, they understand that they can hire professionals. They keep the beneficiary informed. Just because our loved one has disabilities does not mean they're not entitled to be informed. Maryland law says that a beneficiary is entitled to information, and they are entitled to an accounting. If they are cognitively aware of this, they certainly are entitled to see it. So that the trustee has to comply with duties, and they should invest the trust assets as a prudent person would. It doesn't mean that they should be investing the assets themselves. They should hire professionals unless they are a professional themselves in the field of financial planning. They understand taxes at least well enough to know that they're going to hire the professional to deal with the trust and the trust taxes, because trusts do have tax filings and trust income tax. Now, many people say, what can a supplemental needs trust or special needs trust pay for? And we do have a handout that Jeff will be happy to send you, in addition to a memorandum of intent, my article on supported decision making, and what can a trust be used for as far as expenses for the beneficiary, or distributions for the benefit of a beneficiary. So when we talk about this subject, remember that a trustee is either going to distribute funds to the beneficiary, and that is usually not going to be the case in special needs planning, or they're going to distribute assets for the benefit of the beneficiary. And a simple illustration of this is this example. A trustee knows that the beneficiary needs a new computer, so the trustee can do one of two things. They can either give the beneficiary $2,500, or they can simply buy the computer. So buying the computer is a distribution for the benefit of the beneficiary, and that is normally what's going to happen. There are different techniques about using special techniques to give the beneficiary access to certain monies, but that is beyond the subject of today's discussion. We just want to take away that a trust can pay for anything basically within reason that is for the benefit of the beneficiary, although we do have a list that we can provide of a restrictive type trust, which is the first party trust, just to show you how broadly this is interpreted. And I think many of you will be this will be very instructive to most of you. How much should you fund into a supplemental needs trust? Well, many people do not fund the trust during their lives. The third party trust, the one that is part of your basic estate planning, that's okay. It's okay not to fund it. But in a perfect world, would we fund it? And the answer is usually yes. Why? Because none of us know how much money we're going to have at our passing. When we pass and we leave money to a special needs trust, we just don't know how much that's going to be. So should you work with a financial advisor and your team to know how much to fund into this trust? Yes. And two, should you fund the trust now? Yes. Not everybody can do that. It's not a prerequisite, but it is an ideal best practice. And if you cannot fund it now for any reason, certainly we want to do projections and determine how much ultimately should be funded and whether life insurance should be used as a tool. As I mentioned, the first party trust is a trust that allows a person to preserve their assets. So we won't rehash this again in the interest of time. This could be a personal injury award. It could be an inheritance. It could be an adult who is recently disabled, and that person now has assets in their name that they need to divest. So this particular trust is not particularly expensive to put into place, just as a stopgap measure. So many of you who will engage in special needs planning or have your special needs planning reviewed and updated, many of you should probably have a first party trust at the same time, sitting there ready to be used just in case. But that's a best practice, and that's not something you have to do, but that's just a suggestion. So what is the process of establishing a special needs trust? Well, that's the big question right there. Will you use a process? And when you use a process instead of just a transaction, That's the biggest thing I could express to you from this particular series of slides right here. Is process is the actual process of learning. It's the actual process of engaging. It's the time to think that we've been discussing. It's really taking the time to understand what is available to me at the present time in the world. And I apologize for this rather strange graphic, but this is designed to show you that not only do we want you to have a team of advisors ideally, and that could include an advocate, it could include a life insurance professional, and not just the 3 advisors that you see in the middle here. But surrounding that advisory team, you see this process of consideration and learning, and even ultimately a family meeting where your fiduciaries and loved ones come together to learn about what you've implemented so that it will actually work the way that you envision. We talked about guardianship and supported decision making. I won't rehash this except to say that guardianship is the highest form of intervention, and we don't want your loved one with disabilities to lose their legal rights in the traditional sense unless it's absolutely necessary. I know many of you are really torn on this subject. Many times guardianship is the right solution, but even in guardianship, your loved one may have a supported decision maker and not lose all of their legal rights in the traditional sense. Still have certain rights of self-determination that are recognized by the law. And so guardianship or conservatorship is a counseling issue. Guardianship of the person or guardianship of the property or estate, as it says here. Again, we talked about the new Maryland legislation, supported decision making. If you've just heard of this, you're right on the cusp. This was only about 5 months ago that it became law, and we're happy to send you a copy of the article that I wrote about this, not just because I wrote the article, but because in the article I actually reference the legislation, and you'll get a very broad overview, and it's not complicated, very broad overview of what this is. And then I will have to say this, you will decide, and your loved one with disabilities, depending on their level of function and cognitive ability, will decide what this means to you. It comes down from the highest levels, the United Nations mandate on human rights, and now it comes down to our level, and now I will leave it up to you to decide what you think of this and what it means to you and the utility of it for your loved one with disabilities. So this is a tool. I won't take us, just in the interest of time, I won't take us through all of these bullet points, but remember, this is a tool now that recognizes officially your loved one with disabilities has the right to make their own decisions, and they will make their own decisions to whatever extent possible with the support of their supported decision maker. So as we end now, and thank you for your patience as we got started a little slow, and Jeff, thank you for your patience. We want to think about creating a memorandum of intent. It's a lot of work, and you already have a lot on you. So I just send it to you with our blessings to try to think through these things. You can create your own memorandum, so do not feel like you have to use ours, but we will send this to you at your request. Of course, you want to establish or revisit your own estate planning. We want to make sure that your will or trust is properly structured and that the third-party trust, the third-party supplemental needs trust, is properly established. And there's a few ways to establish that. We also want to determine whether we should establish a first-party trust just as a standby measure. We want to make sure that we've calculated our financial needs. We want to make sure that we're understanding the Secure Act. If we are a family that has most of our assets or substantial assets in retirement plans, we want to understand public benefits and make sure our trustees understand them. We want to kind of project all these plans into the future, build flexibility, and start thinking about who will advocate. As I'm really honestly wrapping up here, I promise, I'm just going to pause for a second and say that this is one of the greatest concerns that I know you have, is who will advocate for our loved one in the future. And I will say honestly, on our end, we are struggling with this as well. We are talking to advocates, we are talking to agencies, we're talking to private life care manager companies and firms, the best of the best. And we are all struggling with this about how to best support you. And we know that this is only going to be a solution that is going to continuously have to be addressed. And we're going to strongly recommend that this is something that is discussed in the counseling sessions in special needs planning. And once that plan is in place, that you maintain that plan and continue the discussions into the future, and that all the family members are educated, and the fiduciaries especially. And of course, to make the special needs planning a part of your estate plan. Now, we at Elville and Associates are very privileged. We are here to be consultants to you. We are here to be resources. We do not charge for planning consultations. We don't charge generally to review older documents. I've seen thousands of documents. It doesn't take us very long to review them. So have no fear about this. We want you to provide the information to us with no fear, because I want the thing that I want you to understand is that when you consult with an attorney, if you didn't already know this, there is an attorney-client privilege. There is confidentiality that attaches whether or not you become a client. So there's nothing to fear as far as sharing this personal information, which I know is not easy to do. We would like you to prepare a questionnaire, if you would be so inclined, to tell us about yourself. Bring your current planning documents. If you have documents from the past and they need to be updated, or you did special needs planning in the past and you're just not sure, please let us look at it for you. We enjoy giving you advice about this and looking at what you have and advising about it. Consider whether you have an advisory team, and if you don't be embarrassed. We will help you put one together. Or if you have a partial team, we'll discuss what you need to do to really make this team a whole team. But that's not enough. We want to make sure that after you have a team, we want to make sure that those people are actually communicating with one another and serving you and your family at the highest levels now and in the future after your passing, when your loved ones, your trusted fiduciaries, will carry on that role. Bring your questions. We enjoy your questions this morning, and at a time of consultation, bring those questions. It helps us. It will help organize the meeting. Please don't feel bashful about bringing questions. And again, as we wrap up, our goal is to give you time to think, to educate you, and also educate your loved ones and fiduciaries. So Jeff, with that, I'm going to end in an hour. We did move a little quickly through some of the SSDI slides, but I think that the substance of the presentation, we were able to accomplish it. And I thank everyone for your time and attention. Jeff, I'll turn it back to you.
Well, thanks very much, Steve. As always, great information. And so for our attendees here, we do have some time for some questions, and now would be your time to please get those questions into Steve. If you have one that you haven't sent over to me, and Steve, we do have a couple of questions here that we want to go ahead and address. And one from our good financial advisor friend, Eric, and he asked a good question. It says, Steve mentioned powers of attorney. How many powers of attorney must one have? Do all states require multiple powers of attorney, or might one suffice?
Thank you, Eric, and greetings to you. March greetings. Thank you. The answer is this is going to be dependent on the situation and the I would say the cognitive function and needs of the person with disabilities. So Maryland in 2010 established the Maryland Power of Attorney Act. And the Maryland Power of Attorney Act really got Maryland up on its feet from a very bad set of laws that really didn't govern or really lay down the law, so to speak, on powers of attorney. And it was the Wild West. There was fraud and abuse. Well, now the Maryland Power of Attorney Act says there are two statutory powers of attorney. These are actual forms that are in the code. And the first one is a rather short form. It's the Maryland Power of Attorney. That is what we call the 5-page short form. And this form is kind of the basic form. It covers basic things. It provides for the ability to appoint agents, manage bank accounts, manage retirement accounts, but it doesn't provide for anything that is really what I would call an advanced estate planning or elder care planning power. So a person with cognitive function that has mental capacity, in my opinion, they should sign at least the Maryland statutory form that is the short form. So that is a very basic thing. Now, beyond that, the question becomes whether the person should have a second power of attorney. Now, Maryland has a second statutory form, meaning a second power of attorney that's actually in the law. This is the long form. You see, this is not too technical. This is the long form, we call it. And it literally is an 8.5 by 14, very long power of attorney. And it's quite broad. So it goes from the short form, which is limited, to a very broad form. And in my opinion, there's absolutely nothing wrong with this long, broad form. It's complicated though, and it requires the person to make all kinds of choices, and that's fine too. And if that's what the person had, they would actually have the best of all worlds. They would have a statutory short form and perhaps the statutory long form, or maybe just one of those two. Where I'm going with this is neither one of these forms can really be customized. In other words, the statute says these are the forms, this is what they are supposed to be, and any power of attorney that is created that is a statutory power of attorney. And why is that important? Because the statutory power of attorney is enforceable by law. So in the past, powers of attorney were not enforceable. But if we use one of these statutory forms, and if you're using only a statutory form, I should be clear, you should either use one or the other. But if we're using a statutory form, it cannot be customized to the needs of this particular person. So we generally will use a second form that is created by the law firm, and this is a general power of attorney. And if we use this, this can be customized with special needs type powers for first party trusts, Medicaid spend down powers, and other things that can be implemented into this customized form. So Eric, to answer your question, let's say a person with high functioning cognitive ability would use a Maryland statutory short form and a longer general durable power of attorney that is prepared by the attorney, because now that form can be customized. So I would say a person with disabilities would either use the short form or the long form. In many cases, it would just be the short form. And then a second customized general durable power of attorney, if it was appropriate for the person, would be layered with the Maryland statutory short form. That is one of the approaches that has been used, and we would still say it should be used for a higher functioning person with disabilities. Many times that longer form is so customized and so broad that it's not appropriate for the person with disability. So that's a counseling issue. And I guess the last question maybe that you had was, is this required in Maryland that we use two forms? And the answer is no, it's not required. It's just a technique that has been used since 2010 in many circles. And I am not aware that other states would require two forms, but in Maryland, many times the approach has been to use two forms. Sometimes in special needs, we're just using one form, and that could be just the short form. So long answer to a broad question, but thank you for asking. I hope it made some sense.
Great answer, Steve. I don't think anybody on this call has any questions about powers of attorney now. Really great. Thank you so much. So next question we have here is, what if you have more than one special needs child? Would you need more than one trust?
That is an absolutely wonderful question. And I'm going to say that in my view, in many states, it would be okay to provide for two children with special needs in one third-party trust. I would say in Maryland, the safest approach is to use a separate third-party trust for each child. And then with the Secure Act, the newest Secure Act rules, which are beyond the scope of today's discussion, have special rules about what we would call multi-beneficiary trusts. And they're really referring to third-party trusts. So it's going to depend on whether we are dealing with lots of retirement assets coming into the trust and so forth. But from a very basic answer point of view, we want to use a third-party trust, a trust for each respective beneficiary, in my opinion, as part of your estate planning.
Okay, very good. And there was a question here about our locations, which I can answer. We do have our Columbia location here, which is very broad, which is home to all of our attorneys and staff. And then we have our Annapolis location off of Riva Road, if you're familiar with Annapolis. And that is also available by appointment as well. And we're very happy to meet over in Annapolis. We also have conference room locations in Rockville, at Rockville Pike, Pike and Rose in North Bethesda, and over near the harbor in Baltimore. So I hope that answers your questions about our locations. So if we're waiting for any more questions, we'll go ahead and keep those open. But I'll say, as Steve mentioned, there's many things, as some of you that may have been on this before may know, that I send out afterwards, including the links to some of our other webinars, including trustee selection and Maryland Able, Steve's supported decision-making article, the template to the letter of intent, the uses of special needs trust document, and also information about our upcoming presentations. We do have a little bit of time between our next presentation and this one, which is going to be answers to today's real estate questions. And we're looking forward to that on March 30th. Then we get very busy in April, starting off on April 5th with an in-person presentation at Howard County Public Library about this very subject. So if you'd like to learn about this subject again, on the 5th of April at Howard County Library's Elkridge branch, come see us. We'd love to see you in person. It'd be great to see everybody in person at that presentation. And then on the 7th of April, we're going to be talking about Steve's new presentation about supported decision making. So those are the next few presentations we're going to be offering. So let's see if we have any additional questions here. Doesn't look like we do. Steve, I think we'll call today a success. And please let us know if we can be a resource to you here. That is what we're here for. We're blessed to be in the special needs community. And we thank you for your interest in Elville & Associates and our webinar series. And we'll see you again soon. And have a nice weekend.